Ramaphosa has appointed a new member of the panel to conduct the inquiry into suspended Director of Public Prosecutions, Johannesburg Advocate Andrew Chauke. Attorney Matseho Ramahaha has replaced Tenjiwe Vilakazi. The panel will be chaired by retired Constitutional Court Justice Nkabinde. For more on this, I'm joined now by Melusi Xulu, legal expert. Kabasha, good to have you, and thank you very much for coming on. It's the inquiry this time under the NPA Act. I think the last time we saw such an inquiry, could be wrong, could have been around 2019, and that saw at least two members of the NPA being dismissed. That is Lawrence Mkhwebe and Nomgcobo Jiba. Is it likely going to result in a similar outcome?
Good afternoon, Mdluli, and to the viewers at home. I believe it will depend on the evidence that will be obtained in this inquiry, whether it will go the same route. But like the likely position is that when an inquiry is done, most of the cases in such cases is that there's already strong evidence that there are issues with regards to the fitness of the person that is being investigated. But I do not want to put a cart before the horse. Let's allow the process to unravel, and then Advocate Chauke will also have his chance to defend himself, and then the right decision will be made once everything has been put on the table.
So things that have been brought to question, for example, by Shamila Batohi around Advocate Chauke's conduct, he has dismissed them simply as, normal processes of work in the NPA, saying these things have not put any sort of blemish on his record at the NPA. For example, he says the issue of the dropping of the charges of murder on Richard Mdluli, saying, well, it's just a difference of opinion. I saw it differently, they saw it differently. So it happens in the course of work.
Yes, I think the most important part there will be specific on that murder case against the former crime intelligence head, Richard Mdluli. It will be important for him to show that based on the evidence that was there in front of him, in terms of the legal research and legal opinion, what did he have and what did he put? For example, when you are a prosecutor and there's a decision docket, when you need to make a decision, you need to substantiate why you believe that the charge should proceed or why it shouldn't. And that should be based on proper legal analysis based on the facts that you have in front of you. But the major concern here, Mdluli, is the fact that it could be that there was a very strong evidence in front of him that could not be ignored. And let us remember, the vision of an NPA is justice in our society so that people can live in freedom and in security. So when there are cases which are strong, especially violent cases like murder, and the prosecutor head does not proceed with those cases, that's not following the vision of the NPA itself. So I think the issue is, was there very strong evidence on that part, and did he ignore it? Then his independence will be questioned. But like I said in the beginning, let's allow the process to unravel so that we can hear exactly what was the problem.
So, I mean, it was in 2023, I think one of my colleagues would have put that question to him on that particular matter. And his view was that, well, look, there were, I think he said 2 junior prosecutors who would have done their work, their groundwork, investigated that particular matter. Eventually, they brought it to his attention, and he was the one who then would have assessed that information and made the call at his level. Maybe at a higher level, a different call would have been made. Is that something that could work against him or in his favor? For example, if it comes to this inquiry, by the way, which starts tomorrow, to say, well, the juniors presented this level of information to me, and therefore, at that particular glance, I could have made this decision.
Yes, I think that is very important, Mdluli. The fact that when he was reading the dockets in front of him, and the evidence that he had at the time was not the same evidence that is used now when, for example, the murder charges were reinstated. I think that will be very crucial. But if it's the same, then I don't think it will work for him, because remember, when the prosecutor makes a decision, the first thing that is important is there prima facie evidence at that point? Is there strong evidence? And if there's none, he can simply say to the investigator of that docket, look, can you investigate this? And can you see if this is possible to be added so that I can make a proper decision? Because you do not want to charge a person on a case, whether it's serious or not, but as serious as a murder case and there's no evidence. So if he can say the evidence that was brought in front of me by the juniors was at that particular point not strong enough, but there was further evidence that was brought which changed the whole dimension of my decision, maybe that could support him.
So, I mean, if we look then at the history of cases, and I think he's been under the spotlight since 2011, a number of cases, but the one we're talking about is one of them. The Brian Hlongwa would be another, the Johan Boysen matter would be another, and maybe there are many others that skip my mind at this particular point. Would the inquiry then have to consider the sum total of all these complaints to say there is a pattern of incompetence to some degree?
Yes, I think what they will look at, because if you go to section 12, subsection 6, I believe it's paragraph A, when the president has suspended the NDPP, what they look at for them to make a just decision whether he should leave the NPA after the process, they need to look at his way of whether he's fit and proper to make this when he made decisions, and whether he has the capacity to carry his job effectively. So those are important, and sometimes it's ill-head. But I think at this point, we are looking at him whether he's fit and proper. But all those decisions that he made will be important. The other decision that I'm curious about, Mdluli, I was just researching, I couldn't find whether it will be part of this inquiry, is the Meyiwa case, the Senzo Meyiwa case, because I believe that he also had to decide on the matter. I remember when the matter was proceeding from 2020 that there were some points where he might have been involved, but I'm subject to correction. I would love, though, if maybe there is some information on that, I would love that to be, I think the public has an interest in that one as well, as much as it's continuing as we speak, because it's one of the high-profile cases that was important for the nation. But every case is important, and even the Boysen case that you mentioned in KZN, where Boysen was charged in a wrong manner, but at the end of the day, for racketeering cases, he also was able to win, and there was a review on those decisions. But the issue on that one is that he was pursuing, or the people that he was working with were pursuing it in a wrong manner, and it was, wrongly done against Boysen.
Now, let's talk about some of the terms, I think, that are coming out. I mean, one of the things that they're saying this particular inquiry must look at is to determine whether he properly exercised his discretion in relation to instituting and conducting criminal proceedings on behalf of the state. What are the requirements there?
Oh, can you repeat again? I didn't hear.
I'm saying, they say the inquiry must determine whether he properly exercised his discretion in relation to instituting and conducting criminal proceedings on behalf of the state. What are the permeations there?
Well, I think one of the requirements is for him to do his job without fear or favor, and to do it in a fair way, and to be independent, and to apply the principles in the NPA Act, which are very important for him, and to show some level of independence when he's making his decisions. For example, I'll go back to, I know I dealt with it at a long length, the murder case that was against Richard Mdluli, the former head of crime intelligence. In that case, if it's proven that despite the strong evidence that was in front of him, he declined to prosecute, that shows that there was a lack of independence on his part. But at the end of the day, we will hear everything when it's being shown to us whether he did make a right decision or not. And we've had such cases, like you mentioned, Advocate Andrew Chauke, but the facts may not be the same, but it's to look at his fitness to hold the office. So it will be interesting how it will unravel as it starts.
Thinking back on how that particular inquiry would have been handled in 2019, I mean, are we likely to see the type of evidence being led. They're similar to what we are seeing, at least in the two inquiries that are going on. You've got the ad hoc committee, you've got the Madlanga Commission of Inquiry, where a trail maybe of political interference that could indicate his independence or lack thereof.
Yes, I think what is interesting for me, Mdluli, on this one is that it solely focuses on him. But when you look at the ad hoc committee and the commission of inquiry by Madlanga, those ones are focusing on the criminal justice system and all the other individuals that may be involved in the criminality, corruption of the criminal justice system in our country. But in this one, it's only focusing on him to look at his duty or whether he did his job in the right manner. So the evidence will just be focusing on whether there's enough proof that he did not do his job properly. But I also find it interesting that, the last line of defense when it comes to the criminal justice system, or one of the important people when it comes to the criminal justice system, are prosecutors, because they are the ones that make the crucial decisions whether to prosecute or whether not to prosecute. And if there's any issues with regards to their integrity, what one will say is the last line of defense. So it's interesting that whilst there's an ad hoc committee happening and whilst there's a Madlanga Commission of Inquiry happening, the prosecutor also has his own inquiry into his fitness to hold the office. And maybe soon we might have, I'm not saying that there will be definitely, but I'm interested whether there may be a magistrate or judges that will also be investigated on this based on the revelations that were done on the 6th of July 2025.
Melusi Xulu, I appreciate your time. Thanks so much for coming on. Legal expert speaking there to us about the Nkabinde inquiry into suspended Director of Public Prosecution, Johannesburg, Advocate Andrew Chauke, which will be kicking off on Monday in Pretoria with the National Director of Public Prosecutions, Shamila Batoy, scheduled as the first witness there.